So Section 5 of the code explicitly prohibits discrimination and harassment in employment. And it is very important to remember that this applies to all stages of the employment relationship. Keep in mind that discrimination can happen at the very beginning, at the hiring process. It can happen at any stage during the employment relationship, and discrimination may also be present at termination. Discrimination itself is under the code, it occurs when an individual or a group of people experience adverse treatment on the basis of one of their code protected grounds. Now we're going to get into these code protected grounds in detail a little bit more later, but some of the most common ones we see would be the grounds of race, disability, sex, sexual orientation, marital status, and family status. Discrimination can take many forms. It can be in the form of a one-time isolated incident that is nevertheless discriminatory. And on the extreme end, we can see more of a pervasive, ongoing workplace that would be coined a poisoned work environment. And that's where there's more systemic discrimination. So there's really two extremes there. Discrimination can also be both direct and indirect. So an obvious example of direct discrimination would be making a racial comment or specifically excluding a group of individuals, say people with disabilities or a specific gender from a bonus policy, for example, and unfairly excluding individuals as well. Indirect discrimination can also occur, which can definitely be more subtle and can be harder to detect. So for an example, we all have our own unconscious biases that exist in society. And an example of indirect discrimination, for example, could be an employer screening prospective employees for a job and not giving interviews to people, say, over 60. That would be an example of indirect discrimination. Now, harassment is also prohibited under the code. Any harassment is bad and contrary, obviously, to the Occupational Health and Safety Act. But when we're looking at the Human Rights Code, we are talking about harassment that is based on a code protected ground. So for example, harassment that's rooted in racism or that targets a person's disability. Now, harassment is defined as engaging in a course of ongoing conduct that is reasonably known to be unwelcome by the individual. And in fact, some of the highest damages awards that we see from the Human Rights Tribunal are for the most part harassment cases. And oftentimes when there's sexual harassment allegations, we see a personal respondent being named also. So the duty to accommodate. Let's start first by defining accommodation. So accommodation can, in a nutshell, be defined as employers providing assistance to employees for their code-based needs. And the goal of this is to really provide equal access to all opportunities to employees in the workplace. The duty to accommodate is informed by three principles. Number one is the respect for dignity. So when you're dealing with accommodation, you always want to keep in mind that you should be providing the accommodation that most respects the dignity of the individual. Number two, individualization. And you'll probably hear us repeat this because this is a very important concept within human rights. No two accommodations are going to be the same. There's no one size fits all. You really want to make an individual assessment per employee. For example, you may have two employees, even with the same disability, requesting an accommodation, even though those accommodation plans could look very different. So individualization is very important, and you want to keep an open mind and be flexible with your employees with respect to that. Number three is integration and full participation. Again, this is really the goal of accommodation, which is that to allow employees who are capable and willing and otherwise fit to work to make sure that they are not unfairly excluded in the workplace, and to make sure that they have opportunities for meaningful participation and integration within the workplace. So the employer's duty to accommodate. This is very important to understand that employers have a positive obligation on them to accommodate the disability-related needs or code-protected needs of their employees. Now, there's two aspects or two steps to the duty to accommodate. Number one is a procedural duty. And the key word here is it's a process. It's very important that you do not neglect this stage of the accommodation. Basically, the procedural duty is all about obtaining relevant information from the employee, understanding their limitations and their needs, working with the employee meaningfully to come up with alternative solutions and accommodation plans, and inquiring with the employee and gathering more information so that you do truly understand what their human rights needs are. Again, you want to consider all reasonable solutions. And we always say, do not leave any stone unturned. So to fulfill this duty to procedurally accommodate your workers, you want to make sure you are canvassing all options. An example that I like to use, a little anecdote for the procedural duty, is a case dating back a few years with the Tribunal. However, I think it's still very relevant and adequately explains the procedural duty. And that is a case involving a person who had bipolar disorder, and he did not disclose the fact that he had this disorder at his interview. He was hired for the job, and a few days into his work, he decided to disclose to his employer that he did have bipolar disorder. And he specifically asked for an accommodation, saying that he could feel when his flare-ups were coming, and he was simply asking for some accommodation to be able to take some breaks. Without giving any consideration to the employee's request, the employer terminated this individual on the 8th day of their employment. And of course, this employee brought an application to the Human Rights Tribunal, and the tribunal found that it was discriminatory, that they terminated him, that it was based on his disability. And very interestingly, in this case, the court awarded $45,000 in human rights damages for this employee who had only worked for 8 days. Interestingly, the employee was also awarded with $34,000 in back wages. So again, a lesson to be learned: do not ignore the procedural duty. It's a process. Number 2, the substantive or legal accommodation, which is really the act of the employer providing a suitable or reasonable accommodation to the employee. So while employees do have the right to be accommodated for legitimate needs, they do not have the right to dictate their preferred or most ideal accommodation. They are entitled to, and you'll hear us use this term again, reasonable accommodation, not perfect accommodation. So what reasonable means is really finding the most appropriate solution that meets their needs, but not necessarily meets their preferences. Now, the tribunal has recognized that there are circumstances where, if there are 2 viable options, viable accommodation plans to provide to the employee that equally respects the employee's dignity, the employer is entitled to choose the accommodation plan that is less disruptive and less costly to the organization. So it's always a balancing of interests. Employees also have obligations under the Human Rights Code. So the burden is not only on employers. And the way we describe this is accommodation is really a two-way street. It's a shared responsibility between both the employer and the employee, and it's a cooperative process that both parties are expected to take part in. Employees, of course, have an obligation to request the accommodation. Now, that is subject, very importantly, to the duty to inquire, but generally speaking, employers are expected to ask for the accommodation when they need it. Employees also have the obligation to disclose all information that is reasonably necessary. This could be about their diagnosis, basically about the need for the accommodation. The employer cannot offer accommodation in a vacuum, and they do need adequate information from the employee. Employees also have a duty to accept reasonable accommodations that are offered by the employer. So the duty to inquire, I mentioned this earlier, and it is very important because we cannot always expect that employees will come forward, especially if they have a mental health concern, maybe an addiction issue, and there might be some shame surrounding that, or even there's a lot of stigma, unfortunately, with mental health. So employees may not always come forward. So this is something that you want to definitely keep in mind. And again, just be alert to the possibility that an employee may need accommodation even though they have not formally requested it. So what you want to do as an employer is look for red flags from your workers. If you notice a sudden change in an employee's behavior, for instance, they're suddenly coming in late, maybe they're tearful in the workplace, their appearance has changed, you can simply approach them, and you should approach them and offer them help, see if they need any assistance, and ask if they do need an accommodation. And it really doesn't need to be too intrusive. You're really better to ask than to ignore it. It can be as simple as approaching your employee and saying, hey, it seems like you're not yourself lately. Is there anything I can do to help you, or anything I can do to help? This is definitely an important step to take before you discipline or terminate an employee. So remember this duty to inquire. It's not enough for employers, the tribunal has said, to say they did not know. So the tribunal will always look at whether the employer ought to have known. Okay, so undue hardship. So we've talked about discrimination and accommodation. There are limits to the duty to accommodate, and that is undue hardship. Now, keep in mind that undue hardship is a very, very high bar to meet, and it's really a defense to a discrimination claim. You must make sure that you go through the procedural duty to accommodate before you determine that it would cause undue hardship on the company. And keep in mind here, the key word is undue. So some regular hardship is certainly to be expected. And importantly as well, the employer has the burden of proof to establish that the employee could in no way have been accommodated without undue hardship. And in order to establish this at the tribunal, the employer is going to need real, objective, quantifiable evidence. There are only 3 factors that can be considered in terms of determining whether undue hardship exists. Number 1 is the cost. Number 2 is outside sources of funding. And number 3 are health and safety requirements. No other considerations can be properly considered under this test. So for example, you cannot consider business inconvenience that the accommodation may cause. You cannot consider employee morale or other employee preferences or third-party preferences. The cost standard, again, this is a very, very high standard. Costs will only amount to undue hardship if they substantially affect the viability of the business. And the tribunal has been very clear in saying mere speculation that the cost would be too great or that the company would suffer financial loss is not enough. Again, the employer is going to need to show quantifiable evidence and research that they looked into the costs and that the cost would be too much. Again, you cannot speculate, and it really has to be based on direct evidence. And keep in mind, in many cases, accommodations can be made at little to no cost. So oftentimes accommodation can simply be modifying work duties, offering a more flexible work schedule, or offering or changing a policy. Health and safety is the final consideration that can be made under the undue hardship analysis. So we know, of course, that under the Occupational Health and Safety Act, employers have a statutory duty to keep their workplace safe and their workers safe. Now, of course, employers must balance this duty with the competing interests sometimes of accommodating employees. So accommodation will reach undue hardship only where it will result in a substantial risk to the health and safety of others. And in evaluating the seriousness of this risk, you're going to want to ask, what is the nature of the risk? What is the severity of the risk? What's the probability of the risk? Is it likely, or is it very speculative that that would happen? You also want to look at who it would affect. So would the accommodation substantially affect the health and safety of others? If so, then you might have an argument to make for undue hardship. I'm going to touch just very briefly on the bona fide occupational requirement. This is also a limit to the duty to accommodate, but it's really applied very limitedly. And basically the bona fide occupational requirement is essentially a requirement that is integrally tied to the duties of the job, and it cannot reasonably be accommodated. You definitely want to be careful in terms of assuming that you have a bona fide occupational requirement in terms of your job. I will just briefly touch on an Imperial Oil case. This is a human rights decision. The employer was Imperial Oil, This was a decision, I believe, from 2018. And basically what happened was they had hired an engineer straight out of school. This engineer was in Canada on a student and work visa. He was hired for the job as an engineer, and when he was filling out all of the paperwork, he was required to show that he was either a permanent resident of Canada or that he was a Canadian citizen, which he of course could not show, so the company withdrew their offer. Fast forward to the decision from the Human Rights Tribunal. The tribunal found that the employer acted discriminatory in terms of, not hiring this individual. And what's very interesting, for this employee who never even worked one day, he was awarded $120,000 in human rights general damages and back wages. So let's go into prevention efforts. So what can employers do to really mitigate their liability and prevent a human rights application from even being filed? Number one, we always say, make sure you have the required workplace policies in place. You want to make sure, of course, you have a health and safety policy. You're required to have a harassment prevention policy and a violence prevention policy. Make sure that these are all in place, and make sure none of your other existing policies are discriminatory. We always recommend that employers include an anti-discrimination policy. Now, while this is not legally required, it's always something that we recommend, because it never hurts to have your employees know the process for asking for accommodation if they ever need it. And if you were ever to find yourself before the tribunal is going to ask to see what policies you have in place. So we recommend that you do have the policy, but if you have one, definitely make sure you're also following that policy. This may sound trite, but we always say, practice what you preach. Make sure your policies match your workplace culture. Make sure you are providing a supportive and healthy work environment where employees feel comfortable coming forward. And keep in mind too, the workplace itself is no longer confined to the four walls of your physical workspace. It really extends to social gatherings, business trips, remote working. So keep that in mind too, that employers have the obligation to prevent discrimination in the workplace, which can really be a broad definition. Turning to the Human Rights Tribunal itself, some of you may be unfortunate enough to have some experience with the tribunal. The tribunal does have a very large inventory of cases right now, and they are backlogged, but they are moving through them fairly swiftly. The tribunal obviously becomes involved when the employee commences a human rights lawsuit. These lawsuits can also be brought through the civil courts, but often they are brought in tandem with an action for wrongful dismissal or constructive dismissal. Otherwise, for human rights claims, the Human Rights Tribunal has the exclusive jurisdiction. So the types of claims that we see in the tribunal, of course, discrimination claims, harassment claims, reprisal claims. So this occurs when the employer makes a negative change or an alteration to the employee's work conditions in retaliation for them perhaps making a human rights complaint or asking for a human rights accommodation. So be careful of reprisal. Failure to accommodate. We see the tribunal all the time offering awarding damages for employers failing to accommodate. And keep in mind too that employers can also be found liable for additional damages for the failure to investigate. So don't wait for that formal complaint. Make sure you investigate when you have reason to know that there's something going on. Now, all the applicant needs to show at the tribunal to prove their case is they need to establish on a balance of probabilities that they were discriminated against. That's their prima facie case, which really is not too difficult to prove for the most part. Employers have the more difficult burden. They have the burden of proving essentially a negative. So they have to prove that any action they took or decision they made with respect to that employee had absolutely nothing to do with that employee's protected code ground. So for an example, if we see cases all the time regarding pregnant women who are let go just either before going on maternity leave or after coming back from parental leave, they are terminated. And even though the employer may try to blame it on poor performance or getting rid of, eliminating their position, if the tribunal finds that even 1% of the employer's reason for letting that employee go was due to her sex or her pregnancy, it's discriminatory, and the applicant will be entitled to damages. And keep in mind too that if you do receive a final judgment from the Human Rights Tribunal, it will be publicized and it will be made public. So keep that in mind as well. Very quickly, I'll discuss remedies under the Human Rights Code. So there's no real ceiling for damages under the code. And in fact, we are seeing higher and higher damages awards every year. The trend is definitely continuing upwards. We see monetary damages being awarded, so general damages relating to compensation for the person's, the infringement of their dignity and right to be free from discrimination. We also see public interest remedies, so sometimes that can require policies being made to be put in place or training that the company needs to do. The tribunal also offers a very special remedy, which is not offered through the courts, and that is reinstatement. And that's really applied in really very special cases where the employment relationship has not been severed so much where, you know, the worker can return to the workplace as a result of, for example, being unfairly terminated based on a code protected ground. So keep in mind that employees may be reinstated through the tribunal. Also, lost and back wages. Now, this is really the double whammy that some employers get hit by, because on the one hand, they'll be ordered to pay general damages, which can be quite costly, but oftentimes too, the applicant who experienced discrimination will also be entitled to back wages from the time they were discriminated against until there is a final judgment. And oftentimes those lost wages can even be more than the cost of general damages for discriminating in the first place. So definitely keep all of that in mind. At this point, I'm going to pass the mic over to Ljubica, and she is going to discuss more in detail with you some of the case law updates.
Thanks, Sarah. Are you able to see me and hear me well? I had a message from somebody saying they can't hear me.
I am. I can hear you.
Perfect. Okay. These technical difficulties, we can't get past sometimes. Okay, so I have the fun job of talking about some case law. So putting everything that Sarah talked about into the realm of reality, right? So what has happened to some employers and some employees? Where has discrimination landed them, right? So these are the protected grounds. I'm not going to go through all of them. We don't have time. It would be a very long webinar indeed if I went through each one of them, but I'm going to cherry pick a few of them to talk about where there's interesting cases to discuss. And these are usually the most litigated grounds of discrimination. Before I do go on, though, I did want to say in relation to human rights damages, we've seen the highest award so far that we've seen out of the HRTO is, I think, in the realm of 200,000. And it's going up, right? Like Sarah said, we're just seeing it go up and up. And the other thing too is that these damages are tax-free damages to the employee, meaning that they're unlike wrongful termination damages where you're going to have payroll taxes deducted and things like that. Human rights damages are tax-free to the employee. So there's not a lot to be lost for the employee to start a claim. Okay, so let's get into the good stuff. The first case that I want to talk about is under the ground of discrimination. Sex. Ground of discrimination being sex. Now, the Human Rights Code doesn't specifically define the word sex, but it's generally considered to be related to a person's biological sex. The term includes a broader idea of gender, which is described as the social characteristics attributed to each sex. The protection under this ground, as Sarah already mentioned, also applies to pregnancy, both whether a woman is or may become pregnant. So a most recent case 2021, which I really actually like because there's so many good elements to it, is McGraw and Southgate Township. So a female fire captain and an administrative assistant to the chief for a volunteer fire department was terminated without cause because of rumors in the workplace. The rumors included, among other things, that she sent nude photos of herself to various male firefighters, that she was having affairs with various male firefighters, including the chief, that she was texting excessively with one of the firefighters, that she was causing other firefighters to quit because of her quote unquote behavior, and that she caused morale problems in the workplace. So she was terminated because of these reasons, and she sued to recover termination costs, but also claimed human rights damages based on the ground of her gender. So it was held in this case that the chief relied on rumors to terminate her. And none of those rumors turned out to be factually correct. The chief in this case didn't bother to do an investigation. And really what happened is he had various conversations with a few people here and there to verify the rumors, but everything that was said was hearsay. Nothing was concrete. Ms. McGraw herself wasn't interviewed. And so she was terminated based on the rumors without a real investigation taking place. What the discrimination portion of this case, what it turns on is that Ms. McGraw's male counterparts, who were also involved in the rumors, they were not punished, they weren't reprimanded, they weren't terminated. Nothing happened to them. They were just players in the game, right? And so that showed a sexist double standard to the extent that the court awarded Ms. McGraw moral damages, discrimination damages, defamation damages, punitive damages, and it all amounted to about $190,000. So I wanted to touch on pregnancy because this is a lot of employers deal with this form of discrimination, and maybe they don't mean to. So in this case, Menon and Dr. Monica Spolia, Dentistry Professional Corporation from 2019, Ms. Menon was hired as a dental assistant in March 2017. In June 2017, she found out she was pregnant. She tells her employer the next month, and in July, Ms. Menon is fired after having trained her intended replacement. So essentially, what happened was that when she was hired, Dr. Spolia told Ms. Menon that she better not get pregnant. I suppose dentistry is one of those fields that is female dominated. And so this must have happened to her before. So she said to Ms. Menon, you better not get pregnant. This happens to me a lot. And so when Ms. Menon told Dr. Spolia that she was pregnant, Dr. Spolia was not happy about it and verbalized that. So the HRTO found that when Ms. Menon told Dr. Spolia that she was pregnant, she responded by shaking her head and saying something like, why does this keep happening to me? And Dr. Spolia asked Ms. Menon if she was happy and whether she had decided to keep the baby, etc. But there was that negative connotation. So what happened is about 10 days after the employer was informed that after about 10 days, she was training her replacement. And about 2 days later, Ms. Menon, the employee, was terminated. And the tribunal found that Ms. Menon's pregnancy was a factor in the employer's decision to terminate her employment. So it wasn't the only reason. There was some other underlying reasons. Maybe she wasn't doing that great of a job, but it was even a small factor. As Sarah said, even 1% of the reason for termination, if that is discrimination, then there will be damages. And in this case, Ms. Mann was awarded $20,000 in general damages for injury to her dignity, self-respect, and feelings. There was a question here, if I can get myself. Okay, if she said it in a joking way, does this still go against her? I would say yes, it does, because there's a fine line between joking and telling the truth, right? Sometimes there's a lot more truth in a joke, and people take things differently. They might not take it as a joke, right? So I would say to that question, it would probably land you in the same spot. There wouldn't really be a differentiation unless there's a clear demarcation between the joke and not, right?
And I would say too, it's all about how it's received, right?
Yeah.
So
yeah, and in this case, the judge actually said that that Ms. Mannon was a more credible witness. So when she said that the doctor said it in a serious manner, she was believed over the doctor. So there's that aspect too. Okay, so we're going to move on from that to disability. Okay, the definition of disability includes any degree of physical disability or infirmity that's caused by injury, illness, or birth defects. It includes past and presumed disabilities and invisible disabilities. So for example, chronic pain or color blindness. Mental health is also included. Now, physical disabilities may be easier to observe than mental health disabilities, but they're equally included under human rights law. And they may include personality disorders, anxiety, depression, addiction. Employers should be aware, I wanted to mention here that employers should be aware as to whether their workplace has a double standard for how mental health disabilities are treated versus how physical disabilities are treated. For example, the Human Rights Tribunal has compared a generous sick leave policy related to cancer to how they treat stress leave, for example. The two, if they're largely different, there may be a finding of discrimination. A big thing with disability and accommodation due to disability is medical documentation and sick notes. Requesting doctor's notes is a common and reasonable way to understand an employee's prognosis and job limitations. And they're both types of information an employer is permitted to request. So a relevant and usable doctor's note should contain the following information. I want to stress this because I get a lot of these questions in my daily practice. So what can you ask for when it comes to medical information? What you can ask for is the limitations or the needs associated with the disability, whether the employee can perform and which duties of the job they can perform with or without accommodation, the type of accommodation they need to assist the employee to complete their job. So if perhaps additional equipment is required, or maybe a different chair for someone with a back problem, or a standing desk for someone who can't sit for too long, etc. And then the prognosis and the expected return to work, again, with or without accommodation. Now, it wouldn't be 2021 if we didn't mention COVID-19 in some way, right? So I wanted to add, with regards to medical exemptions, that COVID-19 vaccination policies will fall under this category, and failure to provide a medical exemption to such a policy would amount to discrimination. However, what's currently recognized as a medical exemption to a vaccination policy is very, very narrow. There's only a handful of reasons that an employee might get an exemption or an accommodation for a COVID-19 vaccination policy. And that includes an allergic reaction, a previously known allergic reaction to any of the ingredients in the vaccine, or an allergy to the first dose, or a heart condition suffered as a result of a first dose. I've also heard of some very interesting requests for exemption based on mental health conditions, such as debilitating fear of needles or mental stress surrounding the idea of taking an injection that they don't believe is safe for them to take. So far, these cases haven't been put forth between or before the court or the HRTO, so we don't know how they're going to pan out. But as with all other policies, what's important is the context and the need for the policy to be inclusive and for there to be the availability of accommodation for any of the grounds. So let's get into the case. This is a 2013 case. I wasn't able to find any very interesting recent cases. So this is one where Ms. Wilson, a business analyst who was working at Solis Mexican Food, Inc., received positive performance reviews from her employer during her job. And later that year, in 2013, she complained of back issues. 5 days later, the employer met with the employee and considered whether she was a good fit for the company. She then went on a medical leave due to her back pain, and during her time off, she provided doctor's notes, she completed a return to work plan, and she sent in a form explaining the reasonable accommodations that she required. But these were all rejected by the employer, who insisted that the employee be completely recovered in order to come back to work. They said she can't work at all unless she is completely recovered. And then the employee submitted a final doctor's note saying that she would be back to work in 6 weeks with accommodation. Shortly after that, the employer terminated her due to restructuring, quote unquote. So Ms. Wilson lodged a complaint in the court found that the employer breached Ms. Wilson's human rights and they wrongfully terminated. They said that the decision to terminate was influenced by the employee's disability. So again, it wasn't all of the reason why she was terminated, but it was some of the reason. And because of that, the employer was ordered to pay $20,000 in tax-free human rights damages, and that's not including the $20,000 for termination pay that she was awarded. Okay, so let's go on to the next one, creed. Creed is an interesting ground because it's not defined in the code itself, but it is defined in the case law. And some of the characteristics of creed that the court has found are necessary is that it needs to be a sincerely, freely, and deeply held belief that is integrally linked to a person's self-definition and their spiritual fulfillments. And it has to be a particular, comprehensive, and overarching system of belief that governs one's conduct and their practices. It has to address ultimate questions of human existence, including ideas about life, purpose, death, and the existence or the non-existence of a creator. It also, importantly, has to have a nexus or a connection to an organization or a community that professes a shared system of belief, such as a religion. Now, a belief in a god or gods, or a single supreme being or a deity is not a requisite for someone to fall under this ground. Both widely practiced and accepted religions are considered to be creed, but also other spiritual practices, such as those of Aboriginal cultures, as well as newer religions that are not yet in the mainstream. But those religions are assessed on a case-by-case basis. And again, the court will go through these requirements of creed to decide whether or not they fall under this creed ground. Creed-based complaints often stem from systemic discrimination, where a policy is applied equally to all employees, which results in discrimination. So, for example, in one case, an employee attendance policy rewarded employees for perfect attendance. However, one employee who had to take time off due to their religious obligations wasn't able to have perfect attendance ever because they were required to take those days off. And it was found that, that this policy or this perfect attendance benefit that was given to everybody was discriminatory against this one particular employee. Now, again, the creed ground has been invoked by some employees to try and get out of COVID-19 vaccination policy. So I thought it was important to highlight that here. Again, 2021, we got to talk about COVID. So a lot of employees have tried to get an exemption based on creed. However, most of it has not been accepted. And in fact, the Human Rights Commission themselves released a policy statement at the end of September this year saying that the creed ground doesn't apply to personal preferences or singularly held beliefs. However, they were careful to also state that even if a person could show that they were discriminated against due to creed, the duty to accommodate doesn't necessarily require that they be exempted from vaccine mandates if those mandates were reasonably necessary to protect the health and safety of employees, or if the accommodation would amount to undue hardship, such as during a pandemic. So far, I haven't seen any employers accept an accommodation request under creed. A lot of employees have tried to claim the exemption based on Catholicism, and I think some of our attendees probably have heard it through the news where they claim that because there is some form of human fetus cells within the vaccine itself, or maybe the testing process of the vaccine, that it would be immoral for them to take the vaccine. However, there has been statements coming even down from the Pope himself saying, no, it's fine to take the vaccines, right? So it wouldn't be, it's not easy to prove that your religion is against vaccination, is all I'm trying to say there. But not impossible. And employers shouldn't dismiss requests for accommodation from the outset. It's all about context. It's all, like Sarah said, accommodation requests have to be individualized, and requests have to be assessed on a case-by-case basis. So let's get into the case. Again, 2009, not that recent, but it is a good case to show the fact, the creed exemption. So Mr. Qureshi, a young man of Muslim faith, was being considered for a security guard position. The employer was a large security services organization. Having successfully passed the interview, the employee was scheduled into training. Immediately after explaining to the HR rep that his religion required him to have time off every Friday afternoon in order to pray, the employee was told that the company could no longer go forward with his employment application. The decision at the tribunal was that the employer had a duty to accommodate Mr. Qureshi's request, and it didn't engage in its duty. So even though he hadn't really started yet, he was at the training stage. Nonetheless, there was discrimination found. It was also found that accommodating the request wouldn't amount to any undue hardship, and then it was not necessary for the applicant to disclose his religious need in the interview process, which is what the employer had said. You know, I wasn't informed that he had a religious need. And if I did, maybe I wouldn't hire him. Now that is discriminatory in itself, right? In this case, the employer was ordered to pay $7,500 for lost wages and tax-free human rights damages. So the next ground of discrimination is family status. Well, I'm mindful of the time. I'm gonna blaze through this, okay? So family status under the code means all parent and child relationships. And normally this manifests in a caretaking, in the need for someone to take care, whether it's of a young child or of a parent. This is a unique area of accommodation. And for an employee to prove that an employer's policy or decision is discriminatory due to family status, the following issues are usually considered. Okay. Does the policy have a negative impact on the employee's family need? Did the negative impact actually result in a real disadvantage to the parent-child relationship or a negative impact to the employee's work? Did the employee cooperate in the accommodation process by providing information about their needs and working with the employer to come up with a mutually acceptable plan? And did the employer's efforts extend past the point of undue hardship? Again, that is the threshold, was there undue hardship to the point where the employer could no longer accommodate? The case here is Devaney and ZRV Holdings. The employee worked as an architect for 27 years and was taking care of his ailing mother. This forced him to be absent or late from work on occasion. The employer gave numerous warnings about the absences, said if you don't shape up, you'll be shipping out. The employee kept taking care of his mother and he kept having to take time off and he kept being late. In the end, the employer terminated his employment and the tribunal in the end sided with the employee. They noted that the absences weren't personal choices and they were related to the employee's elder care needs, so the family status ground. The tribunal also found that the employer didn't accommodate the employee's genuine family issues at all, and they didn't even ask why he was absent or to what extent they could accommodate him. So in the end, the employer was ordered to pay $15,000 in human rights damages, and the company was ordered to develop a workplace human rights policy and to train its staff. So let's move on. This ground of discrimination, there's a few of them: sexual orientation, gender identity, gender expression. These are fairly self-explanatory, but I wanted to touch on one case that came out of the HRTO recently that's relevant in this moment in time, as it has to do with pronouns and an employer's use or misuse of them. So in Ian and Gallagher's Bar and Lounge out of Hamilton, three employees of Gallagher's Bar and Lounge were identified as genderqueer, and they identified as non-binary trans persons. They sued their employer, Jamie Gallagher, after he was overheard referring to them as trannies, and when he spoke to customers of the bar, he used those expressions, and they all wanted to have the pronouns they, them used when referring to them. But the employer was dismissive of that fact and refused to use the they, them pronoun. The three employees lodged a complaint at the HRTO, and the tribunal found that by misgendering the applicants and by using incorrect pronouns when referring to them, the applicants were subjected to adverse treatment in their employment at the bar. And the HRTO damages awarded was $30,000, and that was $10,000 per employee. Okay, so being mindful of the time, and I want to leave a little bit of time for questions if there are any. I think we've gone to the 10 steps of accommodation. Sarah, do you want to go through this real quick?
Sure, we can go through this quickly. So there are generally 10 steps to the accommodation process. Number one is you want to consult with and follow your own policies on accommodation. So again, we really do recommend that you have a policy that lays out what the process is for requesting an accommodation. You want to make sure you receive your employee's written statement of their need for accommodation. So it's really best to have everything written down as opposed to having verbal agreements. If you have any questions, we always recommend that you obtain legal advice. Definitely before taking any significant steps, and certainly before you terminate an employee or take steps to discipline them. Number 4, you want to request all evidence that is reasonable in the circumstances. Now, there are limits on this. Again, you can ask for what is reasonable. Generally, we say with doctor's notes, you can ask for prognosis, not diagnosis. So you're not entitled to the details of somebody's mental illness, for example. But you are entitled to all the details relevant to the accommodation. Number 5, you want to determine whether accommodation is required. And I will say generally, you should take all accommodation requests in good faith. And assume they're genuine. You certainly don't want to assume you cannot accommodate and turn somebody down. Number 6, discuss the request, explain available options. Again, this is canvassing options with the client. It's a process and it's a two-way street. So the employee is going to take part in this process. Number 7 is generating the accommodation plan. So once you have canvassed all of your potential solutions, it's a matter of choosing the most appropriate and reasonable solution. Number 8 is implementing the accommodation. Sometimes accommodation could change, so keep that in mind as well. And this is why you're going to take step number 9, which is monitoring the plan, continue to request reasonable evidence as needs may change over time, and the accommodation may need to change over time. So you may come back to that procedural duty. It's never a one-time done process. It's something that's continuous. And number 10, like I said, continue working with your employee. It's a process, and you want to make sure that you keep that open dialogue with your workers. So with all of that being said, I know that's a lot of information to digest. We're happy to answer any questions that anyone may have. You can go ahead and include them in the chat box. If we don't have any specific questions, Ljubica, I don't know, any final thoughts that you can think of, any tips we can give to our client?
So what I would say about accommodation is that one tip that I would give to an employer about accommodation is that the process is really important. They shouldn't dismiss the process, right? So like you said, if there is a request for accommodation, take it seriously. Don't dismiss it offhand. Say, no, I know this person isn't, it doesn't have the creed that says that they can't be vaccinated. I know that this person doesn't have family needs. If you get a request, if you do think that it is not genuine, then you have a duty to investigate that and to figure out whether or not there is some error to reality. Because as we've tried to show you here, discrimination, even a little bit, if it factors even a little bit into your decisions towards the employee, then you are opening up yourself to human rights complaints and damages awards. That's what I would say. That's what I would emphasize.
And the one thing I guess I would emphasize would be the duty to inquire. Definitely don't forget about this. If you think something's amiss with one of your employees, ask them. And it doesn't need to be invasive questioning. You're not entitled to all their personal information, but just check in with them and make sure that you offer resources to your workers, EAP. There's lots of really cost-free accommodations that can be made. And sometimes that just includes offering a more flexible work schedule or potentially changing work conditions or work duties. So if we don't have any questions, we want to let you all go and enjoy the rest of your day. I see it's a little after 10 here. So thank you so much, everybody, for joining us today. I hope we were able to answer any questions you may have. We understand that questions arise as these situations do come up. So please feel comfortable to reach out to us and we'll be happy to help you.
Thank you, everyone. Have a great day.
You too. Bye.